When the Epstein files were released, a lot of people thought this was it. The truth would finally come out. But what was released is not the full story. Because buried inside those documents, there's a missing piece. And that missing piece might explain why some names are still hidden, why parts of the story don't connect, and why this case still isn't over. This is not about what we already know. It's about what's missing. In January, thousands of pages were unsealed. News organizations prepared detailed coverage. The public expected answers. And when the documents became available, people began reading. Flight logs, depositions, financial records, names, lots of names. But also, redactions, hundreds of them. Names like Bill Clinton, who appeared in flight logs documenting multiple trips. Donald Trump, mentioned in depositions about social events at Mar-a-Lago in the 1990s before publicly distancing himself from Epstein. Prince Andrew, referenced extensively in witness testimony. Alan Dershowitz, mentioned in legal depositions. Other prominent figures appeared as well, some named directly, others showing up only as a prominent redacted or an executive at redacted. But here's what became clear almost immediately. Large portions of the documents were redacted. Black bars covered names, locations, details. Page after page contained testimony with key portions blacked out. Witness statements referenced individuals identified only as redacted. Meeting logs showed travel itineraries with destinations marked redacted. Financial transactions listed parties as redacted. The scale of redaction was notable. In some depositions, entire exchanges disappeared behind black bars. Questions visible, answers hidden. Names appeared in one paragraph, then the same name presumably showed up as a black rectangle in the next. Descriptions of events began, then vanished mid-sentence into redaction, then resumed discussing something entirely different. These weren't minor omissions. In critical sections discussing who knew what and when, who facilitated which introductions, who attended which private gatherings, precisely the questions the public wanted answered. The documents often showed redacted, where names or details would have appeared. The missing piece wasn't hidden in some vault. It was right there on the page, covered in black ink. This matters because of what people expected to find versus what court documents are actually designed to reveal. The Epstein case intersected with some of the most powerful networks in the world: political leadership, financial institutions, academic circles, technology companies, media figures. Those connections weren't secret. Many were documented in photographs, event attendance records, charitable foundation boards, academic partnerships. But court documents don't exist to map social networks. They exist to resolve specific legal questions. And when those questions involve powerful individuals, what gets documented and what remains visible after redaction reflects layers of legal strategy, privacy protections, and procedural boundaries. The result is a documentary record that shows fragments. Person A flew to location B on date C. Person D attended event E with Person F. Organization G received funding from Source H. But the connective tissue, what those interactions meant, how they functioned within broader relationships, whether they enabled or facilitated anything beyond what's stated, remains either redacted or simply undocumented. Consider how the documents actually read. A deposition transcript runs for dozens of pages. A witness describes a meeting. Names are mentioned. Then, mid-sentence, a redaction appears. The next visible text picks up discussing something else entirely. What was said in between? The document doesn't say. It can't say. That information was deemed legally protected, irrelevant to the specific claims, or covered by privacy provisions. This creates something unusual: transparency that reveals without explaining. The documents are public. Researchers can read them. Journalists can report on them. But what they contain are data points without the framework that would make those data points meaningful for understanding how elite networks actually operate. The redactions make this even more complicated. When a name appears, then disappears behind a black bar, then reappears several lines later, readers are left to infer what the redacted portion contained. Sometimes the redactions protect privacy of individuals not central to legal claims. Sometimes they shield information covered by attorney-client privilege. Sometimes they remove details deemed irrelevant to the case, but potentially embarrassing or reputationally damaging. The question becomes, what's behind those black bars? Is it another name? A location? A description of what actually occurred at a particular event? The answer is unknowable. And that unknowability is precisely the problem. But the effect, regardless of the reason, is the same. A narrative with gaps. And those gaps are where the missing piece lives. This is not about conspiracy. It's about structure. Elite networks, by their nature, operate through informal channels. Access matters more than formal hierarchy. Introductions carry weight. Being present at certain gatherings, knowing certain people, having certain relationships, these create opportunities that are never documented in ways that would appear in court records. Here's how this worked in practice. Someone attends a philanthropic gala. They're introduced to someone else. Months later, they're on a private island. Years later, that connection leads to a business deal, an academic appointment, access to a different network entirely. None of this generates documentation that would survive in court records. The gala invitation isn't evidence. The introduction isn't logged. The follow-up relationships exist in phone calls, private meetings, unrecorded conversations. Jeffrey Epstein cultivated exactly this kind of network. He positioned himself at intersections, between finance and academia, between technology and politics, between American power and international influence. He facilitated connections, he hosted gatherings, he made introductions. Much of this was visible. Photographs exist, event records exist. But the significance of those connections, what they enabled, what they facilitated, what they meant within the broader structure, exists in spaces where documentation is minimal. The unsealed documents capture moments where these networks intersected with litigation. A witness mentions a dinner. A deposition references a meeting. Flight logs show who traveled together. But the full architecture of relationships that existed around those moments remains largely invisible. This reveals something about how accountability works when it confronts concentrated power. Legal systems can answer specific questions. Did this occur? Was law broken? What remedy applies? But they struggle to reveal informal influence networks that operate through undocumented relationships. The documents came from civil lawsuits with narrow objectives. What gets preserved isn't determined by public interest or historical significance. It's determined by legal relevance to specific claims. If a conversation never created paperwork, it doesn't appear. If a relationship existed outside the litigation, it stays invisible. If context wasn't legally necessary, it wasn't preserved. The Epstein documents show this limitation clearly. They contain extensive information. They name many individuals. They document numerous interactions. But they do so within constraints, legal relevance, privacy protections, redaction protocols, evidentiary standards. These constraints mean that even thousands of pages of unsealed records provide only a partial view. What remains missing is not a single document or a hidden page. It's the explanatory framework that would connect visible fragments into comprehensible patterns. And the redactions, those black bars running through page after page, make it impossible to know what additional context might have existed in the portions that remain covered. Were crucial details redacted? Or were the redactions protecting tangential information that wouldn't have answered broader questions anyway? In some cases, entire pages contained more black bars than visible text. In others, redactions appeared mid-sentence, making it impossible to reconstruct even basic meaning. The public can't know what's missing because the redacted portions are, by definition, invisible. This is the missing piece everyone has been searching for. Not a smoking gun document, not a hidden list, but the connective clarity between documented facts, the context that would make partial information comprehensible as a complete picture. Legal transparency delivered what it promised. Thousands of pages, public access, searchable records. But what it couldn't deliver, what no legal system is designed to deliver, is the map of informal power that operates in undocumented spaces. The dinners where introductions were made. The private conversations where relationships deepened. The unwritten understandings that create access and influence. The documents exist. The names are visible or redacted. The facts are available or obscured. And the structure that would connect them into something comprehensible remains in the spaces where black bars mark what can't be shown and where documentation was never created in the first place. That gap between what was released and what was needed may be permanent, not because of concealment, but because the architecture of elite power was never designed to leave traces that legal processes could capture. The missing piece isn't missing by accident. It's missing because that's how the system was built.